Hey there, I'm estate planning attorney Paul Rambolet, and in this video I focus on the decisions you will need to make when you have one or more children or heirs who, let's just say, don't share the same appreciation for saving and preserving money that you do. In other words, you have one or more heirs who may be in their 20s, 30s, 40s, or even their 50s, and you just know, based on their prior, less than financially mature actions and behaviors, or due to the fact that they are in an unhealthy relationship or they have addiction issues that are difficult to cope with, that they'll spend, give away, consume that future inheritance that you give them if you simply dump that lump sum of an inheritance in their lap when you pass away. Of course, what you'd like to see happen is that inheritance be set aside, managed properly, invested, budgeted, and allowed to improve the quality of life for that child or heir for the remainder of their lifetime. So once you get to the point of, I've seen enough from that child, I've worked too hard to have that child's inheritance just wasted away, when in reality, my child will really need that inheritance to provide for their own food and housing after I pass away. So let's dive into what decisions you will make in order to enable that inheritance for that financially imperfect child to be positive and impactful. So in my mind, there are a few major decisions that you will make when leaving an inheritance in a trust for your child, along with some other decisions as well. So what I'm getting at is, let's say you don't want to dump an inheritance in Timmy's lap. And it doesn't matter what the amount of that inheritance you leave Timmy will be. Timmy's share of your estate could be $200,000, $2 million, or much more. So it's time to discuss what's involved in leaving Timmy's inheritance in a trust for Timmy. Let's call that trust the Timmy Trust. So before we get to the customized provisions of the Timmy Trust, let's talk about the mechanics of how assets are left to the Timmy Trust. So let's say mom and dad have 3 kids and they want to leave 1/3 to each child. So in mom and dad's will or living trust, they will state, among other things, I leave 1/3 of my estate to the Timmy Trust. And the terms of the Timmy Trust will either be right there in the will or living trust of mom and dad, known as a testamentary trust if they are in the will of mom and dad, or if mom and dad have a revocable living trust, the terms of the Timmy Trust are commonly referred to as a subtrust in mom and dad's revocable living trust. Or in the alternative, the Timmy Trust could be its own standalone trust with its own trust instrument. Okay, so now let's talk about the main decisions that you make when you want to avoid leaving a child or heir a lump sum of an inheritance. And since all inheritances are either left outright or in trust, and you don't want to leave that certain heir or child his or her inheritance outright, let's discuss what trust decisions need to be made. One of the first important decisions you'll make is, who will be the trustee of this trust for my heir after I pass away? If you leave, for example, $1 million to a child in trust, then it's the trustee's job after you pass away to establish the trust account at a financial institution, invest the trust assets, provide the appropriate accountings, and make distributions to or for the beneficiary, your child or heir, in accordance with the terms of the trust instrument. So let's go through the trustee selection thought process that parents typically go through when they have a son, Timmy, whose inheritance when mom and dad pass away will be placed in a trust. Mom and dad first discover that trustees are typically individuals or trust companies. Many large financial institutions have a trust company entity that fulfills all of the regulatory requirements when a company is a trustee. Mom and dad first explore in their mind who might be the appropriate individual trustee. They first wonder whether it would be appropriate for one of their other responsible children to be the trustee of Timmy's trust after mom and dad pass away. The concern is that it may create an uncomfortable relationship between Timmy and the other child/trustee, particularly if that trustee has the discretion to make distributions to or for Timmy's well-being. That might create a situation where, after mom and dad die, Timmy constantly badgers his sibling trustee to exercise the trustee's discretion to make distributions to Timmy. So then mom and dad consider one of their siblings as a potential trustee of Timmy's trust. But the problem with this is that the trustee doesn't do anything until both mom and dad die. And since the sibling of mom and dad is roughly the same age as mom and dad, that sibling may not be alive or may not be in a condition to be able to serve as trustee for many years after mom and dad die. So then mom and dad consider naming a corporate trustee, maybe the Charles Schwab Trust Company or the Vanguard National Trust Company or one of the many other trust companies. But the concerns there are they, of course, charge trustee fees. It will be difficult for a corporate trustee to have the type of relationship with Timmy that a trustee needs to have to really understand Timmy's needs regarding when distributions to or for Timmy are truly in Timmy's best interest. And if the inheritance isn't large enough to justify the corporate trustee expending resources to be the trustee, they'll simply refuse to accept the position of trustee when mom and dad die. For example, if Timmy's trust is to inherit $200,000 from mom and dad, a corporate trustee probably won't touch that with a 10-foot pole. But if Timmy's inheritance is $10 million, the corporate trustee is likely to seize that opportunity to charge their percentage of the trust assets trustee fees. But ultimately, mom and dad decide on a trustee or two or more co-trustees to serve as the steward of Timmy's inheritance after mom and dad die. The next major decision is, under what circumstances after mom and dad die will Timmy be entitled to distributions from the trust? There's lots of options here, but the most common trust provisions would provide that Timmy is entitled to all of the income that the trust assets produce each year. Let's say the trust assets are $1 million and the interest or dividend income is $20,000 annually. If Timmy is the income beneficiary, this income would be distributed to him and he would get that. One reason trusts are often set up to distribute the income to the beneficiary is that income distributed to Timmy would be reported on Timmy's income tax return, and Timmy's income tax rate is likely to be far less than the trust's income tax rate that would apply if the income is accumulated in the trust. But then another distributions decision is, when would Timmy be entitled to distributions of trust principal? The most common scenario would be that the trustee has the discretion to make distributions to Timmy during the term of the trust for his health, education, maintenance, and support, commonly referred to as the HEMS standard, HEMS. This HEMS discretion gives the trustee total control over whether Timmy gets distributions of principal. But many people who set up these trusts are comfortable with that, especially if they are very comfortable with their trustee selection, because they often feel that the trustee will do what's in Timmy's, or the beneficiary's, best interest. Other principal distribution options include providing that the beneficiary gets a fixed amount each month, perhaps adjusted for inflation each year, until the trust runs out of money, or getting very specific about when principal can be used or distributed to the beneficiary. But you have to be careful if you're too specific, because sometimes the beneficiary's circumstances 20 or 30 years from now may not have been envisioned when you create the terms of the trust. For example, if you restrict Timmy's distributions only if he, let's say, has a full-time job and gets tested monthly for drugs and he has graduated from college and a bunch of other restrictions, you run the risk of setting up a situation where a trustee cannot make distributions to Timmy, even though it may be in Timmy's best interest to do so. So mom and dad settle on Timmy being allowed to get the trust income, but principal distributions will be limited to when the trustee determines distributions are appropriate for health, education, maintenance, and support. And mom and dad also provide some communication outside of the trust instrument to give that trustee guidance on how that trustee should exercise their discretion. And I'd say a third but related important decision is, when does this trust terminate or end? When the trust terminates, any accumulated income and all trust principal will be distributed in a lump sum to the beneficiary. And if you set this trust up for an adult who is financially immature, options include providing that the beneficiary receives the remaining trust assets when he or she is a certain age, let's say 60, or maybe the beneficiary would get the principal in stages, say 1/3 at 50, 1/2 of what's left at 60, and the rest at 70. Or maybe you give the trustee the discretion to determine when the beneficiary is financially ready to handle it. Or maybe you provide that the trust stays in existence for the rest of the beneficiary's lifetime. Under that provision, perhaps you would provide who the trust principal will benefit when Timmy dies. So those are the main decisions to make once you decide to leave a child's or heir's inheritance in trust due to prior irresponsible life and financial decisions instead of dumping it in their lap in one lump sum. Or heck, maybe you'll be like some people who say, you know what, let them have it. If they blow it, they blow it. It's not my problem, I'll be dead. Anyway, if this is a concern of yours and you want guidance, I've formed a national estate planning law firm called America's Estate Planning Lawyers that helps people all over the country get and keep their estate legal affairs in order. If you'd like to request a Zoom meeting to discuss your particular situation and how America's Estate Planning Lawyers can help, click the link in the description below. I'll go out and have a great day.